should note too that the governor of New York, Hochul, or acting governor, I guess, right? But one of her responses to this, now she's proposed a number of gun control bills that really have nothing to do with what occurred or wouldn't have had any effect on the shooting at the very least. But one of her responses was to try and reform the state's red flag law by requiring police to file for an extreme risk protection order anytime they have probable cause to do so. And she also wants to mandate training on the process for police throughout the state and in the state police. So, is that a solution that, is in line with what you'd like to see?
I'm 100% for training. There should be total knowledge of the existence of these laws. So, on the part of the people who have the ability to bring an action under the law. So I'm 100% in favor of training. I do not like low burdens of proof to secure red flag orders. I don't like a burden of proof that's as low as probable cause. So I'd have to look at the details of what is being proposed, because it could be that you are mandated to seek the order on the basis of probable cause, but you can only secure the order upon a showing of clear and convincing evidence or another standard, which that's fine. But the burden of proof is a big part of this, a big part of this issue.
Right. Let's get into that discussion, actually. So in New York, my understanding is that she wants the police to initiate a request for an order based on anytime they have probable cause to do so, instead of it being a suggestion that they do it. That will be a requirement under what she wants to change. And then in New York, I'm not as clear on the initial seizure order. Seems to be a lower standard to grant that, but then in order to extend it for a year, that's where the clear and convincing standard comes into play. So I'm wondering what your ideal approach is for red flag laws, because this is where a lot of the controversy comes in.
Yeah.
People do not like the idea that a gun seizure could be issued through something like an ex parte hearing, where the person who the order is being issued against isn't available to defend themselves.
Yeah.
And that the sort of hearing that you get comes later on if you request it in a lot of cases.
Yeah.
And so people have issues with that because they view it as a violation of due process rights, especially on when you're talking about something that implicates the Second Amendment and people's Second Amendment rights. So I'm wondering your perspective on all that.
Yeah. So sometimes ex parte orders are necessary. They should be a high bar to grant them. And they're completely consistent with due process in the United States. We have ex parte orders that are often entered when it comes to, for example, restraining orders related to domestic violence and to threats of domestic violence. And my ability to access and, my ability to be with my kids or my wife is every bit as valuable a constitutional right as my ability to own or possess a firearm. In fact, the constitutional structure is more protective of my ability to parent my children than it is of my ability to own or possess a firearm. And yet there are circumstances where extreme danger and extreme risk allows for an ex parte order. Now, the thing about ex parte orders under a due process regime is that you then get a prompt hearing. So even if there's an ex parte order entered, you get a prompt hearing. And that's the key. If you have an ex parte order, but you can't get a prompt hearing, then that's a serious due process violation. But there are emergency situations and all kinds of circumstances where ex parte orders are entered to protect human life, and then you follow that up with a prompt hearing. Now, the problem is
I guess in New York, so just in New York, you get a hearing within 10 days after the initial
Yeah.
orders, places. Is that the kind of timeline
Yeah,
you're
that's
thinking
not,
of?
I would rather it be, you could have a right to a hearing within 48 hours, say. I don't think there's a magic time, but when you're dealing with the temporary deprivation of a constitutional right, then it should be quite prompt. So, my ideal would have a 48 to 72 hour clock where you've got to have the person who's subject to seizure would have a right to be in court. Now, the person who's subject to the seizure may acquiesce to it, may not contest it, and they can choose not to contest. But again, I would say what we want to do is you're looking at a system where very similar to the kinds of risk protection orders or injunctions, or that there's various different names for these for domestic violence protection orders, that the kinds of due process and the kinds of hearing timelines and burdens that exist in that kind of world are a pretty rough approximation of what can exist in the world of firearms, because again, you're dealing with you're dealing with some of the most important liberty interests in your life when you're dealing with access to your own family. And we have procedures in place, though, where you can't access your own family if you're a threat to your own family. And that can be done before you're adjudicated as a felon. That can be done before you're committed permanently, or not permanently, before you're involuntarily committed as a matter of mental health. It fills that gap, right? It fills that gap, but it fills that gap with your family connections or your intimate partner connections. I think a similar kind of process is acceptable when you're talking about you're presenting as a threat to the public or a threat to yourself.